With all due respect, may it please the court.
Good afternoon. My name is Alan Shore.
Mr. Shaw, were there new issues being raised here?
The first issue before the court concerns the absence of any African-American jurors.
That was previously argued and ruled on, counsel.
Yes, before the lower courts. This bench has never considered...
We're not persuaded that the absence of a black juror is in violation of due process. What's your next issue?
I would turn the court's attention to the fact that the grand jury, which indicted Mr. Borns, similarly was all white. This raises equal protection laws.
That issue was never raised and is therefore waived.
Your Honor, Texas law requires that the jury recommend death only in cases where they find that the defendant poses a threat of future dangerousness to society. We maintain this is unconstitutional. Juries are supposed to find elements of guilt and innocence based on facts beyond a reasonable doubt, not on the basis of perceived probabilities. Moreover, as a practical matter, since Ezekiel Borns will remain in prison for life, he couldn't possibly constitute a future threat to society unless the law assumes prison breaks.
Well, that's an interesting issue, counsel, but that also was never raised, and therefore it is deemed waived. Next.
May it please the court. Mr. Borns' trial lawyer has recently admitted he was ineffective counsel. He was abusing cocaine and alcohol during the trial.
Not legally inadequate.
I believe if you examine the transcript...
Mr. Shore, representation can always be better, especially when we play Monday morning quarterback.
With all due respect, this lawyer never gave an opening statement. He never questioned several of the prosecution's witnesses. He failed to pursue a number of leads and important sentencing issues. This court right here today has recognized that many valid grounds for appeal were never raised.
This court is satisfied that the representation was adequate. Is there anything else?
Yes. Mr. Borns may be innocent.
The jury disagreed, and legally that issue has been settled.
The DNA evidence shows somebody else was there.
But it does not disprove that your client was also there. And your guy confessed, by the way.
My client has an IQ of 80. He was interrogated for 16 hours.
Coercion was never raised.
It was never raised because his lawyer was an inadequate hack, though the 9 of you seem quite satisfied with his performance. With all due respect.
Mr. Shaw, you came down here from Massachusetts?
Yes, sir.
We in Texas have been living with this case for 8 years.
You've been living with it personally. May it please the court.
You first met Mr. Borns when?
Yesterday.
And you are proposing to us that you know him. You know what I'd like to propose? I'd like to propose that you got a problem with the death penalty in general. Now, is that why you came here, sir?
I am here, with all due respect, may it please the court, because I have a problem with the state executing a man with diminished capacity, who may very well be innocent. I'm particularly troubled, may it please the court, with all due respect, that you don't have a problem with it. You may not want to regard my client's innocence, but you cannot possibly disregard the fact that 117 wrongfully convicted people have been saved from execution in this country. 117. The system is hardly foolproof. And Texas, this state, is responsible for a full third of all executions in America. How can that be? The criminals are just somehow worse here? Last year, you accounted for fully half of the nation's executions. 50% from one state. You cannot disregard the possibility that something's up in Texas.
I would urge you to confine your remarks to your client and not the good state of Texas.
Zeke Borns never had a chance. He was rounded up as a teenager, thrown in a cell while he was still doped up on drugs, browbeaten and interrogated until his IQ of 80